So the ATF is now trying to use a new Supreme Court decision to expand on and support their SBR rules and to uphold their restriction on pistol braces. Now, really quick before we jump into this video, I want to ask you guys for two favors. First, just double check to make sure you're still subscribed to the channel. YouTube loves to unsubscribe people. And then also, if you're not subscribed, please consider subscribing because that really does help the channel to grow. And then also, if you're interested, I will have links down below to the newsletter. You can sign up for the newsletter, and it's just a way for me to stay into contact with you guys. And we're also gonna be doing some fun things over there where only people subscribed to the newsletter will be entered into monthly giveaways. So again, if you're interested in that, check those out using the links down below. So as I mentioned in the intro, I have some important updates for you with the whole ATF pistol brace cases and their new SBR rule and their expansion on the definition of what an SBR is. The ATF has been suffering a lot of major losses in various cases, and now even more so since the Supreme Court issued that Cargill decision and that whole new striking down of the bump stock rule that the ATF had in place. The ATF is scrambling and trying to figure out how they can protect some of these other rules like their pistol brace rule. And now the ATF is trying to use the Supreme Court's recent 8-1 decision in Rahimi to support the restriction on braced pistols and their expansion of what is an SBR. Now, recently in the pistol brace lawsuit, many of you are aware that Judge O'Connor, the lower court judge, reviewed a case called Mock versus Garland, and in that case, he issued a final merits decision. He granted the plaintiffs there, FBC and some of the other companies, their motion for summary judgment, which struck down the pistol brace rule in its entirety and found that it was invalid. Now, what is really important about what Judge O'Connor ruled in that decision in this Mock case is that he found that essentially the ATF engaged in overreach. They violated the APA because the final rule on pistol braces was not a logical outgrowth from the proposed rule. The proposed rule, as many of you are aware, had a worksheet called the Worksheet 4999. It was in the proposed rule, and you would look at the characteristics and you would add points on this worksheet to determine whether or not this was in fact an SBR. So that was in the proposed rule, but in the final rule, the ATF removed it. And because the final rule was not tied in any way to what they proposed and we commented on in the proposed rule, what Judge O'Connor found was that the final rule was not a logical outgrowth from the proposed rule, and therefore it must be struck down. That decision essentially overrides the limited preliminary injunctions which were issued already in this case. Now, as of right now, the ATF has not appealed that final decision by Judge O'Connor. They have 90 days to still appeal, and I believe that can take place on September 11th, so they have until September 11th to file their appeal on the final merits decision. But the plaintiffs here in this lawsuit, at least one of the groups, is not waiting for the ATF to make their move. Instead, they have filed a supplemental letter notifying the 3-judge panel in the Fifth Circuit that Judge O'Connor did issue a final merits decision, and essentially that the Fifth Circuit's review of the preliminary injunctions is now moot and doesn't need to happen. Instead, all that needs to be decided is whether or not the ATF is going to file their appeal, and all really the battle that needs to take place is about the appeal of the final merits case. But now the ATF is also being a little crafty when it comes to the Mock v. Garland case and some of these appeals when it comes to the pistol brace rule. The ATF has now submitted a 28J letter to the Fifth Circuit arguing that the recent 8-1 decision in Rahimi shows that the lower courts and their outright vacatur of the entire brace rule was in fact wrong. They are now trying to use the Second Amendment decision in Rahimi to support their pistol brace and their SBR rule. They argue that the facial challenge analysis in Rahimi, and in that case, shows that this case here should be sent back down to Judge O'Connor for him to reanalyze this case in light of Rahimi. They also argue that the language in Rahimi supports their restrictions on what the ATF believes are dangerous and unusual firearms, aka just SBRs. Now, in the letter, the ATF argues that Rahimi made clear that to establish that a regulation is consistent with the historical tradition of firearms regulation, the government need only show that the challenged regulation is consistent with the principles that underpin our regulatory tradition, not that a law precisely matches its historical precursors. The government has identified the historical principles that bears on these appeals, that the Second Amendment permits disarmament of instruments that constitute bearable arms that are not typically possessed by law-abiding citizens for lawful purposes. That limitation is consistent with historical restrictions on dangerous and unusual weapons. There is thus no need to excavate the historical record further. They go on to state that the court also clarified in Rahimi that a plaintiff cannot make out a Second Amendment challenge by relying on hypothetical scenarios about how a law applies to other people or other weapons. Plaintiffs do just that, they argue in this case. They argued generally that the law is overbroad because it might reach common, non-dangerous pistols, but plaintiffs have not identified their own firearms or stabilizing braces, and they have not developed an argument for why the law is unconstitutional as to their specific weapons. They go on to say that under Rahimi's reasoning, plaintiffs' facial challenges to the rule and the NFA's regulations for short-barreled rifles must fail so long as those regulations are constitutional in some of their applications. The ATF states that there can be no doubt that these regulations satisfy that test, as at least some braced weapons are short-barreled rifles, and courts have repeatedly held short-barreled rifles to be dangerous and unusual. Rahimi also underscores why this court should not affirm any injunction on independent Second Amendment grounds. The district courts have not applied the lessons of Rahimi and should do so in the first instance. So not surprising that you now have the ATF arguing that Rahimi and its historical analysis allows the ATF to essentially expand on SBR laws and try to hold that braced pistols are in fact SBRs. This type of argument is what Justice Thomas was a little bit concerned about and why he was the only dissenter in the majority opinion in that Rahimi case. Thomas wanted to keep the Bruin analysis as tight and limited as possible to essentially avoid this type of wiggle room where the ATF is now trying to use some of the language in Rahimi, essentially saying that as long as they put forward some justification for these laws, they can overcome the burden. So Thomas was a little bit worried about what is happening here in this case. Now, do I think the ATF's arguments are going to fly? Not really. I think it's a weak argument, but still they're trying to use some of the language in Rahimi to support this ban. Now, also interestingly, the ATF has submitted 2 other Supreme Court cases to try to justify what is going on here and ultimately why Judge O'Connor and his decision needs to be struck down. Now, one of the first ones they put forward is talking about universal relief. It's something we've talked about in some other cases, essentially dealing with some of these ATF overreach cases. They put forward a case dealing with the Starbucks Corporation versus McKinney, and they essentially argue that the Supreme Court has said universal forms of relief or nationwide vacatures of rules, shouldn't be permitted. And essentially that's also what happened here in the Brito case, where you had Judge Kaczmarek, who issued a nationwide vacature of the rule. And they said that this universal nationwide broad relief is no longer permitted by the Supreme Court, and therefore those decisions should also be struck down and sent back down to the lower court for more limited forms of relief. And then they put forward a new case, a different case, which deals with the FDA, and they quote to some of Justice Thomas's concurrence and essentially arguing that limited relief also for organizations where you maybe get relief for an organization and their memberships should also not be allowed. What's interesting about that, of course, is because you have preliminary injunctions in this case where you have protections for organizations, let's say like FBC and their members, or SAF and their members, or NAGR, GOA and their members. Here, what you have the ATF arguing is that type of organizational relief should no longer be permitted and should be in fact struck down. And courts like Judge O'Connor or Judge Kaczmarek, who are issuing those types of relief, should not be allowed anymore. So it's very interesting now with these appeals dealing with pistol braces and the expansion of SBR language. You now have the ATF trying to pull together multiple Supreme Court decisions, the Rahimi Second Amendment case, then you have the Starbucks case about universal relief, and then also you have now this FDA case about associations and membership protections. They're trying to pull all these together to support themselves on appeal, essentially to strike down what the lower courts have said. So it's going to be very interesting to see how this develops going forward. Again, if we get any more information, if anything else develops, I will let you guys know. So if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.